There are no respondents present. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And do you all swear or affirm the testimony you give us the truth, the whole truth, and nothing but the truth? Thank you. And just for the record, we have no public or respondents present at this time. And I believe you want to take cases out of order, so I believe there's been a request to take case number 2024-805 as the first one. Yeah?
Yes.
You can call that case.
Case number 2024-805, Donnelly Cologne, owner, location violation 1424 Kentucky Avenue, St. Cloud, Florida.
Good afternoon, Pam Neal, Code Enforcement Officer. I am presenting this case for the property located at 1424 Kentucky Avenue. At this time, I would like to enter into evidence the following items: copy of the courtesy notice sent to the owner, copy of the notice violation sent to the owner, copy of the notice violation sent by certified mail to the owner, copy of the statement of violation and notice of hearing sent by certified mail to the owner, copy of the statement of violation notice of hearing with the new date posted on the property and City Hall, copy of the affidavit of posting, copy of the PowerPoint presentation, evidence of mailings, copy of the deed to the property, copy of the code section in violation, copy of the costs incurred if the special magistrate finds the respondent in violation in the amount of $275.96. And the respondent is not here. On April 24th, 2024, I received a complaint about a vehicle with no tag at this location. On April 24th, I went to verify, and there is a black SUV with no tag parked in the side yard at this location. I took one photo. On April 25th, a courtesy notice was sent to the owner. On May 10th, a reinspection was performed, and the SUV was still there with no tag. I took one photo. On May 10th, a notice of violation was sent to the owner. On May 28th, a reinspection was performed, and the SUV was still there with no tag. I took one photo. On May 29th, the notice of violation was sent to the owner by certified mail. On June 17th, the reinspection was performed, and the SUV was still there, but backed in, and I couldn't verify if it now had a tag. There is also a gray SUV with no tag, and I took 3 photos. On June 18th, a statement of violation and notice of hearing was sent to the owner by certified mail. On June 27th, the reinspection was performed, and the property is still in violation. I took 2 photos. Second one. On June 28th, 2024, a statement of violation and notice of hearing with the new date was sent to the owner and posted on the property on City Hall. An affidavit of posting was completed. I took 1 photo. On July 11th, the reinspection was performed, and the property is still in violation. I took 1 photo. On July 15th, a reinspection was performed, and there is a temporary tag on the SUV, but when I ran the tag, it comes back to a black vehicle trailer. So I took 2 photos. It is the city's recommendation that the respondent be found in violation of allowing an abandoned vehicle at this location and to have the vehicle properly tagged with the correct tag for that vehicle or removed from the property by August 1st or pay a fine of $250 a day until compliance is met. The city would like to also recover the costs incurred in bringing this case before the special magistrate in the amount of $275.96 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
Respondent who's come in is not on this case, is it? Okay. Not this one, okay. Based on the evidence testimony received, I'll find in favor of the city, find the respondent is in violation for allowing improperly registered vehicles, right? There's still 2 on the property?
No, there's just the one now.
Which
but
one is there now?
The tan SUV.
Okay. The second one that came on after, the black SUV is now gone.
Yes, sir.
So there's just the one vehicle.
And it's got a tag that doesn't match it.
Order the respondent to cure the violation by August 1st, 2024. If the violation is not brought into compliance, I'm going to order a daily fine of $100 per day until compliance is met. Order the respondent to pay the administrative costs incurred by the city in the amount of $275.96. That amount will be due within 7 days from the date of my written order.
Thank you.
Sir, the respondents are here for cases 2024-629, which is the third item on the agenda, and 2024-832, which is the fifth item on the agenda. Those are.
You okay taking those out of order?
We can take those out of order as you see appropriate, yes.
Officers okay with that? Okay. Then if you'll call 629.
Case number 2024-629, Aretha M. Ware, owner, Richard T. Ware, owner, location of violation, 1814 Dumbleton Place, St. Cloud, Florida.
Good afternoon, Melissa Howes, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: a copy of the courtesy notice of violation, copy of the notice of violation sent by regular mail, a copy of the notice of violation sent by certified mail, a copy of the statement of violation and notice of hearing sent by certified mail, posted on the property and City Hall, a copy of the statement of violation and notice of hearing with the corrected time of the meeting posted on the property in City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $240.96. The respondent is here and has been given a copy of everything I'm presenting to you. On March 18, 2024, after receiving a list of delinquent business licenses, this location did not renew their business tax receipt or certificate of use licenses for the business Wares Unique Services Incorporated. An email was sent to the business to advise that the licenses needed to be renewed. On March 20th, a courtesy notice of violation was issued by Catherine Day, the administrative assistant, to the owner of the business, who is also the owner of the property, to correct the violation within 10 working days. On April the 10th, Catherine received a call from the owner stating he would be in that week to pay for the licenses. On April 23rd, the licenses were not renewed, so I issued a notice of violation by regular mail to correct the violations. On May the 9th, the licenses were still delinquent. I sent out a notice of violation by certified mail, which was signed for on May the 11th. On May 31st, the violations were not corrected. I reached out by telephone and no one answered. The mailbox was full, so I could not leave a message. I then emailed the business advising them I would give them until June 3rd to renew, or I would be scheduling this case to the special magistrate. On June 3rd, the licenses were not renewed. I sent out a statement of violation and notice of hearing by certified mail for the July 17th special magistrate meeting. On June 20th, I had not received the certified mailing card back, so I posted the property in City Hall with a statement of violation and notice of hearing, did an affidavit of posting, and took a photograph of the posting. I also had to, let me give you the photo real quick. So on July 1st, I actually realized that I hadn't changed the time from the meeting from the month before. We changed it to 3:30 instead of 3. So I went back and I posted the property in City Hall with a corrected statement of violation and notice of hearing. I did an affidavit of posting and took 2 photographs. Upon checking, the licenses were renewed on June 21st, 2024, so they have complied, but not within the time specified. It is the city's recommendation to find the respondent in violation of allowing a business to operate with a delinquent business tax receipt and certificate of use license at this location by the time specified. The city would also request the cost incurred in bringing this case before the magistrate in the amount of $240.96 to be paid within 7 days of the written order by the special magistrate. And that concludes my presentation. I don't know if the owner wants to speak. No? He's good.
Okay, just a couple of questions, and since it's in compliance now, more just for my own curiosity than anything else at this point. So is the business operating out of the home?
Yes.
And what is the city's evidence that there was a business being operated out of the home? How do we know the business was operating? Obviously, it's come into compliance now, so it answers that question. But I was curious, just as I was hearing the case, if they were not in compliance now, that would have been my question: is what is the evidence to show that that the business is actually being conducted?
There is none other than the fact that they didn't renew from the year before. So unless they, let us know that they've closed the business, we're to proceed.
Based on the evidence testimony presented, I will find in favor of the city, find that the respondent was in violation for failure for operating a business without the proper local business tax receipt. I find that violation was cured after the time allowed in the notice of violation for cure, but prior to the day's hearing. So I'm going to award the city its administrative costs incurred in prosecution in the amount of $240.96. The amount will be due within 7 days of the date of my written order. And we'll find that, again, it's finding that there was a violation. That violation is now in compliance. And so the significance of that finding is that if it happens again, it could be prosecuted as a repeat violation, which there's a greater risk of fines for you if that happens. So that's really, it makes it important to make sure to not let the same violation happen again. Okay? And you'll get a written order to everything I just said. You'll get a written order that has all of that in it. Okay?
Thank you, sir.
Case number 2024-832, Renell Did 13 Inc. and NPZ Trading LLC owner, location of violation 1429 Hamlin Avenue, Unit 8 and 9, St. Cloud, Florida.
Good afternoon, Alex Miller, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: copy of the notice of violation sent by regular mail, copy of the notice of violation sent by certified mail posted at the property in City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted at the property in City Hall, copy of the PowerPoint presentation, affidavit of posting, evidence of mailings, copy of the code sections in violation, and a copy of the deed of the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $283.42. The owner is not here, but the tenant is here, and he was provided with copies of the case. On May 6, 2024, while verifying another complaint, I observed 2 AC units were being installed prior to obtaining a permit. I made contact with the contractor and the occupants explaining the violation. I also inquired if there was a new business coming to the location, and I was told that the units are being used for personal use, and I provided the occupants with the contact information for the license and the permit, and provided 7 days for them to come in compliance, and 2 photos were taken. On May 14, an email was sent to the owner advising him of the violations, followed by a phone call on May 16. The owner
Officer Miller, let me stop. Just explain what you're showing me in this photograph.
So there was the 2 AC units that were being installed on the date of that I found the violation. But I'll explain it with the case. They obtained the permits, but the licenses have not been obtained.
Okay. I'm with you.
Okay.
So this violation, that
It was
has been
cured
I got
as
it.
part
Now,
of the case.
I've caught up. Okay, now, because I wasn't seeing it, that was what I was doing. I wasn't seeing it in the agenda, so what is this violation? Now I follow
Yes.
you. Okay.
So May 14, an email was sent to the owner advising him of the violations, followed by a phone call on May 16. The owner advised that he contacted the tenant, and he was advised that he is working on correcting the violations. Additional time was provided to come in compliance. On June 5th, a re-inspection was performed and verified that the violations were not corrected. A notice of violation by regular mail was sent to the owner, agent, and tenant to correct the violations. On June 6th, I called the owner and advised him again that the application for the AC replacements were submitted but not obtained, and that the tenant has not obtained the business tax receipt and certificate of use licenses. On June 16, I verified that the violations were not corrected, called the owner again, and advised him of the findings. The information was also provided by email. A notice of violation by certified mail was sent to the owner, agent, and tenant, posted the property in City Hall. While posting the property, the tenant came to the door and stated that the permits were obtained, and he was also advised that licensings will not be required for the units. I explained that the permits were not obtained, and he will need to contact the licensing department as soon as possible. One photo of the posting was taken. On June 25th, I received a call from the tenant stating that the permits were obtained, and I explained to him that the permits have not been obtained. He also stated that he will be submitting the paperwork for the licensing. I called the contractor's office and requested that they pay for the permits so they can be issued. On June 28th, I verified that the permits were obtained, but still no business tax receipt and certificate of use were obtained or applied for, and the property was still in violation. A statement of violation and notice of hearing was sent by certified mail to the owner, agent, and the tenant, posted the property in City Hall, and created an affidavit of posting, and one photo of the posting was taken. On June 12, 2024, I verified there's still no business tax receipt and certificate of use on record, and the property is still in violation. It is the city's recommendation that the respondent be found in violation of allowing a business tax receipt and certificate of use licenses to not be obtained for this property by the time specified. The city will also recommend that the respondent be given until August 1st, 2024, to obtain the business tax receipt and certificate of use, or to pay the fine in the amount of $250 to be assessed until compliance is met. The city will also request that the cost incurred in bringing this case before the magistrate in the amount of $283.42 to be paid within 7 days of the written order by the special magistrate. And this concludes my presentation.
Do I have Lieutenant is here? Go ahead. You would start with stating your name for me.
Robertson Marte.
Yeah, and swear you in. Do you swear from the testimony you give the truth, the whole truth, nothing but the truth?
Yes, sir.
And your name again, I'm sorry.
Robertson Marte.
Okay.
So when we had rented this warehouse, it's me and my business partner's personal use. We didn't understand the prior tenants had started an AC, so I thought I just had to call someone to finish it. And, learning with her, I found out the whole process. I'm a first-time business owner, so I'm kind of learning everything as I go. Right before she had posted that sign, I ended up actually calling here, and I was asking, hey, we don't sell nothing. We're using this area as personal use. We put a basketball court in there.
When you say you're using as personal use for what?
So me and my business partner, our business is trading online. So we trade from home. Our business is based out of New Jersey. We just live here in Florida. So we trade from our computers at home. Like, we have home offices, but there's a lot of, like, when we first moved out here, we didn't know this much suburbs. So, like, there's not, like, areas to go play basketball. There's not areas, so we just thought it'd be cheaper to just rent a warehouse every time we want to go play basketball, or we have TVs in there to be able to play video games instead of always making a mess at our house. We're not inviting nobody else over. It's just a business for us, if that makes any sense. We have no physical employees in the state of Florida. Everybody's based online.
Is your business registered with the state of Florida?
It is registered in New Jersey.
Do you have any Florida registration?
I think, I'm not 100%, I know you can search us up on Sundays, but our address is based out of New Jersey, Theodore, Road.
I'm just curious, is there, code enforcement, if either of you, is this address listed with their Florida registration?
No.
Okay. City attorney, if, does the city have any argument that if I take the testimony as true that they're using it for personal use, does the city argue that they are supposed to pay for a BTR?
Yeah.
So, like, when I came back to the office and I talked to Mr. Marte, what he explained to me is that when he is talking, I guess, to the people from the media, instead of taking them to the house, he brings them to this location. So he's actually conducting some kind of business here, because personal use is not allowed in industrial locations. So that's what I told him to contact the licensing department.
The reason I asked the question of the city attorney, though, is both Florida statute and local ordinances will track the statute is very specific on what circumstances trigger the obligation to pay a BTR or pay for a BTR. And it is a main or branch office, I believe, if I remember that statutory language correctly.
Give me just 1 second.
Uh-huh.
Can you show me the code language you've cited, that's what I'm gonna see.
So
Show me
that's,
this.
Okay, so BTR, BTR, and certificate of use.
It's okay. We'll pause for a second. I'll let you talk more. It isn't. I'll give you the microphone back.
I just wanna read the site. I'll point to it, because I don't, which portion? The entirety of this?
Yes, sir.
Okay. So under the code, and I won't read ad nauseum, but at the outset of the code, which has been cited and it's cited here in the case, 12-132, nope, it's been acknowledged by the respondent that they're engaging in business from the location. No person, firm, or corporation shall engage in or manage any business, profession, trade, amusement, or industry in the city without first making application, having procured a certificate of use for each location. It says it right there in the code.
Certificate of, so that's your argument as certificate of use. How about the BTR? How does the BTR come in? And BTR is really what's giving me the pause.
That's the section 40-132.
And this is an analogy I use with my clients when we have questions over BTRs. I don't have a BTR from the city of St. Cloud. I am conducting business right now in the city of St. Cloud. It is more than just the conduct of business within the jurisdiction that triggers the BTR requirement. It is the office, I think, that triggers the BTR requirement. Having an office.
A location.
That triggers it. Correct.
Yes. The section states, no person, firm, corporation shall engage in or manage any business, profession, occupation, trade, amusement, or industry in the city without first making application, having procured a local business tax receipt from city manager, designee, etc., which local business receipt should not be used prior to receipt of the amount you're going to have to provide.
So then you agree that the interpretation of that is a fixed location where I'm conducting business?
Well, it is. Factually.
Well, that was my threshold. Now I want to come back to the evidence, because now we'll explore the evidence, because the testimony from the respondent is, I don't do business there, so let me get the respondent back to the podium. So I heard that the statement has been made that you bring clients here.
So when she had came and asked, at that point, we're not even like fully done building. So at that moment, we're trying to figure out what could we use. We just got this location. It was the only place big enough for a basketball court. So at that point, we're trying to come up with...
Are you playing basketball with your clients?
No, just me and my business partner. We actually have videos online.
Why did you tell the code enforcement officer you bring clients
because she was asking, what did you guys get this thing? She was trying to explain to me what the business was for. And I said, oh, look, all of our business is based online. We do online subscriptions. We don't meet with customers ever.
Do you market?
What was that?
Do you market?
Market.
You know what marketing is.
Marketing? Do we push marketing, like ads and stuff like that?
No, do you market? Do you go out?
My business partner is a YouTuber with 1 million subscribers.
How do you generate?
Well, no, it's word of
all
mouth.
online, or is there any?
All
do you
online.
have face-to-face clients?
No face-to-face clients. Everything's online.
I'm still struggling with why did you tell code enforcement that you bring clients here?
Well, no. So what I was trying to say, she was asking, what would we be using this warehouse for? I said, oh, who knows? Maybe in the future we'd bring people here, or maybe if you walk in right now, We have no physical walls. We have a gaming station and a basketball court.
Are
I
you
even-
bringing clients there to market?
No, no marketing whatsoever. All
You
of
know
our
you're under
business,
oath.
I'm under oath. All of our business is 100% online.
You know, if you're lying to me, it's perjury and a criminal violation.
I'm telling you, telling you right now, if you go to our website, everything is based online.
And if in
through
3
Zoom
months
call.
the code enforcement officer is there and you're entertaining clients
That's-
there,
That's
you
fine.
will have committed perjury.
Well, also too, can I add now to the story too or no?
Please.
So that the same day when she came, she also said, "Hey, look, you can't have signs on the doors and all of these things." And I'm like, "Okay, look, I'll take them down." I just paid $2,000.
Why did you have signs in the door?
I don't
This
want
was just
I
for
don't
personal use.
I don't want nobody to see through the glass.
What did the signs say?
You know, I just said MPZ Trading Forex Factory. We had
Sure sounds like a business.
no, I know, but it's just for the outside. It had no time, no way. We don't have a phone number. We don't have nothing on this door to be
But
able
you're
to schedule.
advertising your business.
Well, we took it down the same day, 2 days later, after she had said that. And then since then, I've been talking with the leasing, what do they call the people that we signed our lease from?
Landlord?
Landlord, and they've already are working on a sublease. We're looking to get out of it because I came here twice already too, and
So it sounds like you maybe had ideas to use it as the business, and now you've rethought that.
no, well, what we found out what we couldn't do in the future was we've already since then we've been bought out and we're moving to Miami. So since June 16th, since the first time I saw her, I came here and I've spoken downstairs with them twice, and they were like, "Are you selling anything here? Do you have any physical things that you're selling and people go pick up? Are you doing?" And I said, "No, I have a filled out BTR with me on me, just in case if I needed it. I'm not trying to be out of compliance. I'm not trying to make headaches for myself or nothing. But my understanding was that when I did speak to somebody here, and I came here physically twice, and heard from 2 different people, was that how I'm not selling nothing there, and my business is 100% online, which it is.
Where do you conduct your business from?
Zoom calls.
No, where are you sitting
My
when you
house.
take that call? Where
My
is your
house,
house?
32 Amberley Park Circle, Kissimmee.
I will caution you
Mhm.
that just because your work is online,
Mhm.
your office is your house.
Okay.
And you could wind up in this same predicament in
For
Kissimmee.
my house. So and how do I, as a new owner of a business and starting this, how do I work from home or how do I do these things? Because when I came here and filled it out and I'm kind of talking to people, I'm learning everything either through online. Like I spent a week on you guys' code book trying to understand, and then I noticed that on the 9th, you guys switched everything again from, so it was kind of hard for me to navigate. How does somebody like me get help to be able to do the right? Because I want to do right by my by my business. I'm not trying to pay fines. I'd rather use that to grow my business in another way.
Chamber of Commerce, I don't know for St. Cloud. I am just the hearing officer, so I don't work for the city. I come here to hear these cases as an independent hearing officer, but I don't know what resources are available in this county. But to that question, Chamber of Commerce is
Right.
always a very good resource for those kind of, I'm starting a business, what do I need to know type
So
questions.
like right now, our warehouse, just because of the issues, me and my partner are scared. We kind of just shut it down. Luckily, we got bought out 2 weeks ago, so we will be going to Miami regardless. But even prior to 2 weeks, I already signed an agreement with my landlord. They're looking for a subleaser to take over the 3 years because we will no longer be living in this area.
Is that the name, Business Economic Development?
Well, they do Business Navigator. They
Well, we have my
a
phone number there.
position that can
We
help.
just did that because the designer did that.
I'm just, what do I tell him? What do you,
Well,
right
we
there.
have a Business Navigator that
Okay.
we can speak to.
do we have, who is that person?
Let me
The clerk was telling me they have a business navigator that works with the city, that works in the city, that also helps new business owners, and I think she's looking up the name of that person. Yes.
I just wanted to add that when I went to post the property, the sign as he's talking about, he had on the sign, it says call for appointment. Even though he didn't have a phone number, he had a Twitter or Instagram account posted on the property, and I'm trying to find the pictures. I didn't put it on the pictures because that's not part of the violation. But when I tried to talk to him about it, he said that literally he was not going to take the TikTokers to his house, so he had to take him to this location, and that's the reason why he had the location to conduct the business there, to the TikTokers. So that is conducting business at this location. And I have asked him, requested him since the beginning, back in May, to contact the licensing department, but at no point he contacted the licensing department because we're in the same building. So I was trying to work with him for him to get information, but that's the information he provided to me. And he removed the sign, but he had called for appointments on the door.
because I know the respondent wants to be heard. I think at the outset of the respondent's presentation, he acknowledged that he is doing business from the location. He then went on to put that into a context or a framework to evade a finding of noncompliance. But the bottom line is that a finding of noncompliance would simply give him a time to comply or cease doing business at the location.
Well,
There's no
here's the thing, though,
harm,
is he's told me he's not doing business now.
but he has been, is our position, without the appropriate documentation, which would be
So ceasing to conduct business does not cure the violation. Is that what you're saying? Is that the city's argument?
No, I'm saying that there ordinarily with all cases, there's a time for compliance to be confirmed with the city before there would be any kind of.
So what your argument now is that he was in violation, he's cured the violation by ceasing, no.
Not quite. What I was just trying to point out is that in all these code enforcement cases, even with a finding of noncompliance for first-time violation, there's a time within which to confirm compliance, and as long as that's met, there's only a cost penalty, but there's not a fine. And so my point being is that if now the respondent moving forward is going to come into compliance.
Let me tell all the parties where I'm headed in my head, unless I hear something that steers me off of it, is based on why I was going through and making sure the respondent understands that he is sworn, and if he's lying to me, that's a crime.
Yes.
Is that based on what I've heard so far, I'm inclined to find the respondent was in violation because the respondent, I think, had the intention of using it as a business and started that process. Then when they found out that there were going to be other issues, I think they peeled it back. So I think there was a violation. I think they've cured, if what you're telling me is true. But if code enforcement, and they are, will keep their eye on that property, and they see business being conducted here, you're going to be back here as a repeat violation, which means you could be fined $500 a day, back to the first day they saw you doing it, and if I find out you were lying to me, I'm going to enter that fine, $500 a day.
And then also, can I ask you, I've hired the same company that installed our ACs to actually remove them, like in the next week, we're gonna take them with us to Miami. I do wanna say, like I said, just like I kinda told them, and kind of what I was explaining, we had ideas of what we wanted to do there or not, and then through research, after signing the lease, we explained it to our tenant before, but I'll be very honest with you, now learning what I've learned now, they're not very helpful. They just want us to sign the paperwork, you know what I'm saying, lock us in, because now we're helping you get out of this, but you still got to pay monthly, which I've been doing regardless. If you think about this, not to say this like in a bad thing, I love here, I was raised here, but in reality, there's not a lot of like TikTokers, influencers in general. We fly to Miami to work, we go to LA to work, we go to New York to work. I leave today, like at the end, I just postponed my travel things to leave at the end of the day back to Miami to go back to work. And I just want to, like I said, I want to just like a clean cut of whatever I have to do. The fines are not what scares me because I do have the BTRs. I just want to make sure that I'm good with the city when I do walk out of here.
But if you think you may use that for any type of business purpose, my suggestion to you would be to go ahead and file that BTR and get that certificate of use permit and the BTR because they're not expensive.
Yeah.
You know, that's the frustrating thing whenever I hear BTR cases is it's a very small amount of money and we'll spend more time talking about it here than it would take you to go downstairs and get it.
Yeah. No, I walked down. I got the physical. The lady printed
So
it out for me too.
if you do that, then you're good with the city and you use that for a business purpose. You can use it for your marketing. You can use it for. So
we're already out of here, so it doesn't matter.
in that case, is there anything else from the city?
Just to make sure there's on record that if he wants to remove the AC units, he'll have to get a demolition permit for the units.
Has he got a demolition permit?
Correct. That's all.
So you were permitted and finalized in for the installation?
Yes, to remove the AC units.
No, I mean, but they were the
Yes.
that he cured the violation.
Yes,
that
yes,
guy
sir.
wasn't cured
Yes,
the
sir.
earlier. Okay. Anything else from anybody?
No, sir.
Okay.
You have to go to the second place.
So my finding in the case is that the respondent was in violation, cured the violation by ceasing the business operation. So I will not order any compliance because I'm finding it now in compliance. I will order the respondent to pay the administrative costs incurred by the city in prosecution in the amount of $283.42. Is there any hardship in paying that amount within 7 days? You can pay now. I will give more time if somebody asks me more time. That's why I asked the question, but you can pay before you leave today. And again, the importance of this finding is that if there is a repeat, there is a much more significant fine that can be imposed.
I have a question too now that we're, and this could be with you guys too, and I don't care how this time gets answered. I just want to know the general parade. I'm moving to Miami August 1st. I'm paying this warehouse until somebody subleases it, right? So I'm paying $5,000 a month regardless, and I have to keep electricity and water. Am I able to park a car in there? Am I able to do anything personally that I would want? So I could at least use it. Like I have a storage, one of those that I'm holding stuff for like couches and stuff. Can I hold my personal stuff in there, or is that a fine too?
So that's the reason why you have to check with the licensing, because it's like industrial, it does not allow for personal use of the
Okay.
units, yeah,
All right,
unfortunately.
see, and that's what I'm just curious, because now I'm just paying this thing, and this is going to be sitting there. So I wanted to see if I could just move, at least cancel my $30 a month, or $50 a month in storage, and use that. But if I can't, that's fine. I was just curious. Thank you.
Thank you. Oh, the clerk has asked me, how are you paying?
Does it need to be checked, or can I
Yeah.
pay with my card?
Yes, you could pay by check. If you could give this to the lady behind the door, she will take your payment.
And I can't pay by card? Or no?
No, sorry.
So I have to come back anyway then. So I don't have a check on me.
Oh, okay.
Thank you.
Then just call, they give you my information to call me to make an appointment.
Thank you so much. You guys
Thank
have a blessed day. Thank you so much.
Did we have another respondent up here?
518. Case number 2024-518, Ariel Montero, owner, Abreu Shanley Aquino, owner, location of violation 3449 Harlequin Drive, St. Cloud, Florida.
Melissa Howes, Code Enforcement Officer for the City of St. Cloud. I don't know how I want to proceed with this case. So the respondent is now telling me he is not in business. Why he hasn't reached out to me, I don't know. He is still active on Sunbiz. So
As to what address?
that his own,
This
Well-
address?
yeah,
Present your case.
present it? Okay. Okay, so at this time, I would like to enter into evidence the following items. A copy of the notice of violation, copy of the notice of violation sent by regular mail, copy of the notice of violation sent by certified mail, copy of the statement of violation and notice of hearing sent by certified mail, posted on the property in City Hall, copy of the statement of violation and notice of hearing sent by posted on the property with the corrected time of the meeting, posted on the property and City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $241.96. The respondent is here and has been provided copies.
Thank you.
On March the 7th, after receiving a list of delinquent business licenses, this location did not renew their business tax receipt or certificate of use. I sent an email to the business to see if compliance could be met prior to issuing any notices. On April the 8th, the city's computers went down for 2 weeks, so no renewals would have been accepted, so I didn't check again until April 18th. The licenses had not been renewed. I sent out a courtesy notice of violation to the owner of the property, who is also the owner of the business, to correct the violation within 10 working days. On May the 7th, the licenses were still delinquent. I sent out a notice of violation by regular mail. May 29th, still delinquent. I then sent out a notice of violation by certified mail, which was signed for on June the 1st, putting the date for compliance on June 17th. On June 17th, I called the number on file as a last attempt to obtain compliance prior to scheduling to the special magistrate and left a message. On June 20th, I had received no callback and the licenses were not updated, so I sent out a statement of violation and notice of hearing for today's magistrate, posted the property on City Hall, did an affidavit of posting, and took one photo. On June 28th, I realized I didn't change the time of the meeting back from 3:30 to 3 o'clock, so again, I posted another statement of violation and notice of hearing with the corrected time of the meeting on the property and City Hall. I took 2 photographs of the posting and did an affidavit of posting. I checked the licensing records today. They're still showing delinquent. So it's the city's recommendation that the respondent be found in violation of allowing a business to operate with a delinquent business tax receipt and certificate of use license at this location by the time specified. The city would recommend that the respondent be given until August 1st, 2024 to come into compliance or pay a fine of $100 a day until compliance is met. The city would also request the cost incurred in bringing this case before the magistrate in the amount of $241.96 to be paid within 7 days of your written order. And that concludes my presentation.
And as you were first introducing the case, you'd mentioned that the property is still
showing active on Sunbiz. If you'd like a
still
copy.
showing as active on Sunbiz.
Yes.
Anything else for the city at this time?
No, do you want a copy of that or no?
Yes, that'd be helpful. Respondent, you can come on up. Thank you. If you'll raise your right hand, I'll swear you in. Do you swear from the testimony you give us the truth, the whole truth, and nothing but the truth?
Yes, I swear.
Thank you.
So, like I told her, I'm not operating the business anymore, and since last year, May last year, I didn't have an idea how to fix this, and I would like to get this solved.
Your name for the record, please.
Ariel Montero.
So here's what I think you need to do to get it solved. Because while you're similar to the last case in that you're telling me now that you're not doing any business.
No,
As far as the state of Florida is concerned, though, this is your principal place of business. So how to fix it is to go, I don't know exactly what his steps are. Who did you use to register your LLC? Did you do that yourself?
I didn't know myself.
Okay, so then you know about registry. You're just going to need the same thing to put that onto inactive status. So you need to contact. Who runs Sunbiz, Jack? Do you remember? Is it Department of State? Department of State Division of Corporations, and tell them that you need to make your. Thank you. The Department of State that you need to make your LLC inactive. I suspect it would happen on its own if you just abandon it. You're going to be put into an administratively inactive status. But what needs to happen is if you will take that LLC inactive, that will allow code enforcement when they look and see, oh, the business is inactive, it will now line up with what you're telling me. So I believe you when you say I'm not doing business anymore. The problem is that as far as the state of Florida is concerned, this is still an active business, and this is where it's located. So I'm going to give him plenty of time to do that, just in case he has. So do you think you can get that done in 60 days, just getting that registration changed? So I'm going to find the respondent is in violation, find that the respondent needs to put the LLC into an inactive statement with the Department of State in order to cure the violation. I'll allow the respondent 60 days to accomplish that. That date of compliance would be September 15th, 2024. If not brought into compliance by that date, a fine of $100 per day for each day the violation continues. But I will tell you, if, as you start this process, if you have problems or if there's something that we're not thinking of, call the code enforcement officer and let her know. And because he's trying to do the right thing, it seems like, so I don't want to make it harder for him.
Yeah, there will be an administrative resolution for failure to file the annual report. That's sometime issued, I believe, in the summer.
So that might be right around the corner.
That's not far. It still shows, I just checked on Sunbiz is active and current, and he can proactively file articles of dissolution on Sunbiz to dissolve the LLC, presuming that he's in fact dissolving the entity.
What business were you in? What did the business do?
Deliveries?
Deliveries?
Yeah.
Contractor for Amazon, stuff like that?
Yeah.
Are you still doing that work?
No.
When did you stop doing that work?
May of last year.
Of last year?
Yeah.
I don't know if it's code enforcement officer or city attorney. Where I'm pondering this one, and it's just fairness and justice on the request for administrative cost. If he has not been conducting business since last year, I don't doubt that in his mind, the business was done. And this is a very technical, legal type of issue with the Sunbiz registration. I'm inclined to not impose the administrative cost in this case due to its facts. Does the city have anything to say about that?
As long as he complies. If he doesn't comply within the 60 days, then you would.
I think that's fair. So I'm going to hold in abeyance the order on costs, and as long as you do what we're talking about here and you get that registration changed so that the business is no longer active, the cost that the city has asked me to impose will also be waived. So you will walk away with an order finding that there was a violation, telling you what you needed to do to cure, but you won't have to pay any fines or any costs or anything.
All right,
Okay?
thank you.
And you'll get a written order that explains all of this, so you don't have to remember it tonight. Okay? Thank you.
Case number 2024-384, Urdaneta Immigration Services, owner, location of violation 4156 Southern Vista Loop, St. Cloud, Florida.
I'm going to allow Officer Miller to approach, but I believe this is a case that's being no process. Is that not correct? She wishes to no process case. She's resolved it. I'm sorry.
Case number 2024-861, Cameron Scott Uranin, location of violation 86 Blackberry Creeks Drive, St. Cloud, Florida.
That one's also going to be no pros.
That's why I don't have a request.
Correct.
Okay.
Unfinished business, notice of hearing and motion for amended findings of fact, conclusion of law and order. Case number 2023-1358, Robert Goddu, owner, repeat, location of violation 810 West New Nolte Road, St. Cloud, Florida.
I just double checking to see if the respondent is here. Don't see anybody here. We brought this back before you, Your Honor, because the case was heard back last year. There was a finding of non-compliance, time to come into compliance, et cetera, and Officer Bennett will give you more detail. But over time now, the violations have become more serious and have reached a point where we really needed an amended findings to make that express finding of a serious threat to the public. So with that, I'll turn it over to Officer Bennett.
Understood, and I have the orders in front of me, so I recall enough of the case. You can tell me what the changed circumstances, and you can skip right to that if you want to.
Okay. So since the original hearing on September 1st, I did a compliance inspection and asked for an affidavit of non-compliance because the case was not in compliance at that time, and I took 7 photos at that time. There are going to be a lot of photos for this case, so I can explain.
What am I looking at? What's under the tarps?
So under those tarps are accumulation. He's put up tarps just to block it from public view, but there's a lot of accumulation.
Piled up?
Yes. And those are kind of hard to see. So those were the ones that were taken that I had requested the affidavit of non-compliance at that time. On February 5th, I received a call from a neighboring property advising of the condition of this location, asking for the city to please bring some relief to their neighborhood. I advised that the property was presented to the magistrate in August of 2023 and is running daily fines. The complainant requested that I perform an inspection due to the unsanitary conditions, so I did. On February 6th, I completed the inspection. I was able to verify that the property was still not in compliance. The condition of the property remained in unsanitary condition, and I observed open ground burning pits. At this time, I did not act on the complaint due to already running fines for the observed violation. 10 photos were taken. That's one of the burn pits.
Remind me where the junk and debris is coming from.
It's all over the yard now. It was when the previous
Where
case
is
was,
he bringing it in from is what I'm trying to remember.
he hoards, so he goes and collects it from trash at the road and brings it back to his property.
That's what I thought.
On June 9th, an email was received from an Osceola County Sheriff's deputy in reference to the condition of the property, asking for somebody to do an inspection at the location. On June 10th, 911 had received a call for service due to a large fire in the front yard at this location. I was again notified of the condition of the property. On June 12th, a reinspection was completed. I was able to verify a large burn pile in the front yard. I was not allowed access to the property at that time. I did make contact with the property owner to discuss the condition of the property. I also advised that there was to be no open ground burning. During this interaction, it had appeared that Mr. Gadu had recently been involved in an altercation. He had a black eye, facial bruising, dried blood on his head and his ears. I asked if he was safe. He advised that he had some issues with some people that are squatting at his house. And at that time, 11 photos were taken. After consulting with my supervisor and the city attorney, it was decided this case would be reopened and brought back before the magistrate due to the serious threat to public health, safety, and welfare of the community. On June 20th, a notice of hearing and motion for amended finding of facts, conclusion of law, and order was sent out by regular mail and certified mail to the property owner. On June 24th, the notice of hearing and motion for amended finding of facts, conclusion of law, and order was posted on the property and City Hall, and 7 photos were taken. On July 1st, I had received an anonymous letter from a neighboring property describing the conditions of this location and again asking the city for help. The letter also stated that dogs at this location were not being fed, nor did they have water. This prompted me to verify if this location had power, since the water is supplied by a well at this location. So I called OUC to verify the service and was advised that the power was cut for non-payment on June 21st. A reinspection was completed. The house was red tagged for no utilities, no water. The property owner allowed us access to verify the condition of the property. At the time of the inspection, the property owner had another open ground burning pit. He was asked to extinguish that fire. He was again advised that there was to be no open ground burning, and 39 photos were taken. This one, I'll go through these pretty quickly unless you need me to stop. On July 8th, I called the complainant and advised that, on July 6th, I had received a voicemail stating that there was a large fire in the rear yard. So on July 8th, I had called her back and explained that if she does see any fires there, that she needs to call the fire department, so that way it's on record. I also made contact with the property owner at this location again and advised again that there was to be no open ground burning at this location. On July 17th, which is today, I contacted OUC to verify if there was any power back on at that location. It's still without power at this time. And then the city requests that the special magistrate enter an order amending the August 22nd of 2023 finding of facts, conclusion of law, in order that the special magistrate make a specific finding that such violations do now present a serious threat to the public health, safety, and welfare of the community, and therefore also, by such amended order, notify the local governing body, which may take all reasonable repairs which are required to bring the property into compliance and charge the respondent with reasonable cost of repairs along with fines imposed pursuant to section 162.9091 of the Florida statutes. And that concludes the presentation.
No respondent is present, and you've met your burden. I mean, the city has definitely shown common substantial evidence to show that there is an immediate threat to health and safety welfare. What is he burning when he burns?
Everything. Bicycles, clothes, toys, any plastics.
That in and of it, that's a toxic burn. I mean,
Correct.
That's why that's one of the reasons I'm making that finding. Both what goes into the air and what goes back into the ground. I also do have, that's why I noted the height of some of those piles. Those also, that creates a safety risk. Ultimately, it's fortunately for me, I guess none of my business how the city goes about correcting it. But I don't think I need to tell anybody in this room. But just make sure that everybody else who works for the city, who doesn't work in code enforcement, doesn't go to trainings where they tell us about these things. I mean, if this is, and it looks like it's a weird hoarding situation in that he's burning the things that he's hoarding, but if it's hoarding, it is a mental health thing, and police involved, and I mean, it's a big deal when you do into whatever cleanup you do. Just, I know you all know that, just make sure everybody else who's involved does too.
Yes, sir.
So instead of an amended order, what I'm going to do, I'm going to do a supplemental order and make this as a supplemental finding, because really it's the finding that triggers the authority of the city here. But I will enter that order, yes.
Thank you. Thank you, yes. You can give it to her. I don't think he needs it, but you can give it to her. For the file, sure. Thank you. Nice job, Erica.
Reduction of lien under 50,000, case number 2023-216, Manuela Tasquin Lopez, owner, location of violation 811 Georgia Avenue, St. Cloud, Florida.
Your Honor, Jack Morrison for the city. Apologies on this. This has been worked out. This is under 50,000. There was just I don't know what you'd call it, not a typographical error, but just an error in the information in the body of the settlement agreement, but I did the math. The numbers all work out. So the hearing dates and such, all accurate. The compliance date was actually June 6th of this year, which made it a 272-day violation, $100 a day. The city and the respondent have agreed to a reduction down to $2,981.80 to resolve the matter on this case, if paid within 30 days. Dealt with unmaintained, unsafe vacant structure, high grass weeds, and such from last year.
Anything else?
No, sir.
And based on the argument presented by the city, I will find in favor of the reduction, approve the reduction to the amount of $2,981.80, subject to that being paid in 30 days. If it's not paid in that amount, the fines will revert to their original amount.
Thanks, sir.
Reduction of lien over 50,000, case number 2022-1516, Luis Samuel Negron Rodriguez, Ana Rosa Torres Padilla, location of violation 5108 Foxtail Fern Way.
Jack Morrison for the city. This was a violation that when the respondent failed to obtain the active permit within time allowed, and case was heard in November of 2022, and compliance was ultimately achieved just earlier this month, July 9th of 2024, which was 581 days of accruing fines of $100 a day, totaling $58,100. So this would be, we're requesting that you recommend to council that the matter be resolved. City manager and respondent have agreed to a reduction of down to $6,036.78 if paid within 30 days to reduce that matter and resolve it for the city.
Okay. I will enter an order making that recommendation to the commission.
Thank you, sir. Nothing further. Thank you.
New business, none. Next scheduled meeting, August 21st, 2024.
Do you want to formally introduce your new supervisor? On the record?
Come on up.
Hello, I'm Everett Cole, new code enforcement supervisor for the city of St. Cloud.
Well, welcome. We're glad to have you here.
Thank you. Thank you for having me.
Anything else from city? No, sir. Clerk?
Nope.
We are adjourned.